Mental health has become a primary focus for pretty much every level of government in Canada. And while virtually everyone knows that Canada has major hurdles to overcome in regards to properly treating mental illness, the proposed solutions are varied. And the debate about those solutions is one that is filled with turmoil. Last month, the province of Prince Edward Island passed a law creating community treatment orders which can be used to force those with mental illness to get treatment. Joining us now to discuss this development is Meagan Gillmore, journalist with Canadian Affairs. Meagan, thank you very much for being back with us.
Thanks so much for having me, David.
So, what exactly is a community treatment order and how does it work in practice?
Sure. So, community treatment orders are legal orders. They're enacted through mental health acts in various provinces and territories. And what they do is when a patient is being admitted from the hospital who has a serious mental illness, often a symptom of their illness may be that they don't recognize that they have an illness or need treatment for it. A community treatment order says that they must remain on their treatment, and if they don't, then the police can take them to the hospital to get their treatment. So what it does is it allows somebody to get their treatment in the community and not in a hospital. But it is a legal document. Often it's signed by substitute decision makers. And patients who are placed on a community treatment order do have the option to appeal it if they believe that they do not need one and should not be on it.
And where else in Canada has implemented this program?
Sure. So, according to researchers I spoke with when we were working on this article and just doing a survey of different laws, every province and territory now has a form of community treatment orders. In some provinces, they may be referred to by a different name, but the general idea is still the same.
And some have said that what PEI is doing here is too restrictive.
Yeah.
What are their arguments saying that this is too restrictive?
Right. So in the Mental Health Act, it sets out the eligibility criteria. Like, who gets a community treatment, or like how do you get to be one of those people? And the requirements in PEI say that somebody is eligible if they have had at least two hospitalizations to a psychiatric unit, involuntary hospitalizations in the last 2 years that combined equal 30 days. So that's two things. One is you must have had two hospitalizations in the last 2 years, and the second one is that must equal 30 days in hospital. So if you had four hospitalizations, but they were just a week long, you would not
Mhm.
qualify because that would just be 28 days. So the concern is that by having both those requirements, the requirement of the number of hospitalizations and the requirement of 30 days, that this is keeping people who may benefit from a program like this off of it. And it's also different than what other provinces have. So, for example, in New Brunswick, which many people consider to be the least restrictive community treatment order in Canada, in New Brunswick, there is no eligibility criteria attached to hospitalizations. It's up to a psychiatrist to determine that you have a serious mental illness and
Mhm.
you need continuing care in the community.
And on the other side of this debate, some feel that these treatment orders are institutionalizing those who are mentally ill and an infringement of their civil liberties. Walk us through that side of the argument.
Sure. So that concern is the fact that if you are an individual who is in a community treatment order, yes, you're out in the community, but there's still the state is imposing restrictions on you, right? So you'll have mandated doctor's appointments for you to get your treatment. In some cases, there may be requirements on where you're living. Different types of supportive housing, that sort of thing. And then if you decide, hey, I don't want to do this treatment anymore, then law enforcement can come, take you to a hospital, and you are forced to get your treatment again. So it's that concern about um, you don't have in the argument against it, you do not as an individual have the right to voluntarily say I do or I do not want these treatments. It is being placed upon you by a community treatment order, and it should be stated that community treatment orders are not forever. there
Mhm.
there is a time period that they're attached to, typically 6 months or a year, and they can be renewed. But the concern by people who are skeptical of them is that the patient cannot say for the length of time of the community treatment order if they do or do not want treatment.